Larry here with 7 Sage Law School Prep and another stick figure exam tip. This one's called How to Outline Part 2. In a previous lesson, How to Outline Part 1, we discussed the microstructure of an outline. That is, at the case level, how do you actually structure the few sentences that you write about a particular case for maximum effect? Quick review, this is bad. Where you have useless information here, tons of facts, and the holding last. What you want to do, sorry for the scribbles from last time, is start with the disposition of the case, the generalized legal rule, the name of the case, and a very quick summary of the facts, just enough to jog your memory. That's all you need. I promised in that lesson that we would come back and discuss the macro structure of the outline. How do you fit those cases together? And here's the secret, or not so secret now, organizing principle that can be applied to many outlines, not necessarily all of them, but it's quite useful as to many of the subjects that you'll take. And it's called the case or issue spectrum. I'm a fan of Breaking Bad, if you can't tell. So what do I mean by case or issue spectrum? Hopefully most of you are young enough not to have to deal with this, but let's say you've got a house. That's better than this one. And let's say that your wife asks you to paint the house. She wants to paint it this funky color. I don't know why, but somehow she's managed to find in a magazine it was just the little swatch of color and she wants that. So Jesse Pinkman wants to sell you paint. And you show him this little color swatch here. And he says, "Oh man, you can mix the paint. I'm not sure if I've got that." That's the worst Jesse Pinkman ever. So instead of showing up with this paint, he gives you the paints that they do have and you can mix from there. So Jesse runs to the back and he shows up with something like this. It's a color spectrum. It's a number of paint swatches that have samples of the paint colors there, right on a bunch of little sticks, so that you can take an old paint color that you used to have and compare it to what you have. So what is it that you do? You kind of take the swatch and you go, "Oh, it's not red. I just created a hole in the space-time continuum. Oh, it's not orange or whatever that is. Oh, it's not yellow. Oh, it's not green. It's not blue. No, it's purple, but it's not exactly purple. I guess I could mix purple and blue or something like that here." When you're having trouble on an exam and you need to resort to your outline or even your mental outline if you're not allowed to bring one in, this is implicitly what you do. You take the case that you have and you have an array of cases that are organized along some sort of spectrum from less X to more of it as you get farther down the spectrum. So here are some common outline spectrums that you can set up. This is not an exhaustive list, and neither am I going to say that you can always use a spectrum for every part of your outline. Sometimes it's not appropriate. There's a lot of contracts, for instance, that doesn't necessarily lend itself to this kind of a setup. But a lot of things do, a lot of doctrines do. Civ Pro was one of the first ones I did this for, and I got an A in the class. You've got a spectrum of no personal jurisdiction to clear personal jurisdiction. You have lots of contacts and less contacts here and various rules pertaining to general jurisdiction, depending on the kinds of claims that are set up, or specific jurisdiction. In the area of con law, you've got discrimination cases and executive authority cases that also fall along spectrums. With discrimination, you can have a spectrum of protected classes from very protected, race, sex, something in the middle like sexual orientation, to non-protected classes like profession maybe. There's a series of executive authority cases in the Youngstown Steel line that also lends itself to this analysis, where you've got high executive authority where it's clear that Congress hasn't taken the field in something, to very low where it's clear that Congress did not mean to delegate powers to the president. In crim, you can do a homicide issue spectrum. So it's a little bit different from these. These, you've got your set issue, and the question is whether or not a case, the exact fact that you have, falls at this point or this point or this point in the conceptual spectrum that you've set up. Here you've got different doctrines that are set up and facts that might fit along here. So if you think of a spectrum of intentionality, if that's even a word for killing someone, you have intent to kill, murder here, and negligent homicide here, and along the spectrum you might have reckless and depraved heart or something like that. And for torts, the entire body of tort law could be put on a spectrum if you wanted to do that. Also on the spectrum of intentionality, how much mental thought went into what happened by the tortfeasor. Here you have intentional, something like battery, getting punched in the face. Here you've got negligence, where the court is basically saying if you'd really thought about it, you wouldn't have done it this way. We know you didn't mean to do that, but you could have put more thought into it. And maybe strict liability here, where something's so dangerous that we say to the tortfeasor, you've got like radioactive waste that you're driving around neighborhoods. We don't care how careful you are. It's so inherently dangerous that anything bad that happens, we're going to say you're liable for. So those are some common spectrums